Residential report writing and case studies. Chapter 8, disclosures of scope of work and something with the name. Example of disclosure. Unnecessary approach. Whatever you wrote in our case study exercise about the unnecessary approach, it is unlikely that you wrote as much as this. At the request of the client, development of the cost approach has been attempted by the appraiser as an analysis to support their opinion of the property's market value. Because there is insufficient market evidence, to credibly support the site value / derivation of total depreciation, the cost approach is not given any consideration in the appraiser's final analysis. Use of this data in whole or in part for other purposes is not intended by the appraiser. Nothing set forth in the appraisal should be relied upon for the purpose of determining the amount or type of insurance coverage to be placed on the subject property. The appraiser assumes no liability for and does not guarantee that any insurable value estimate inferred from this report will result in the subject property being fully insured for any loss that may be sustained. The appraiser recommends that an insurance professional be consulted. Further, the cost approach may not be a reliable indication of replacement or reproduction costs for any date other than the effective date of this appraisal due to changing costs of labor and materials and due to changing building codes and governmental regulations and requirements. This example is excerpted from an article titled "The Cost Approach: To Do or Not to Do" from the website of Liability Insurance Administrators, www.liability.com. One important point in this course, we are primarily concerned with disclosing the appraisal process clearly and accurately so that the intended users understand the scope of work and are not misled. This example takes it a step further by employing a detailed and extensive scope of work. Disclosure in an attempt to limit the appraiser's liability. End of page. Unavailable information. Previously, we addressed the appraiser's obligation under Standards Rule 1 through 5 to analyze current agreements of sale, options or listings of the subject property, and also research a 3-year sales history of the subject property. Sometimes the information regarding current listings, agreements, options, or prior sales history is simply not available. USPAP states that when this happens, the report must include commentary regarding the appraiser's efforts to obtain the information. Advisory Opinion 1 addresses this situation and even provides some sample comments that can be inserted in appraisal reports. This is one such sample comment. The property being appraised is known to be the subject of a pending purchase and sale agreement, but the appraiser was unable to obtain the terms of the agreement. The current owner confirmed that the property is under agreement, but declined to disclose the terms of the nature of the agreement. If the property had been transferred within the past 3 years per public records, but the details were unavailable. The subject property was sold by John Jones to the current owner on June 1st, 20-something, for an unknown price. The appraiser attempted to obtain the purchase price and other terms of the transaction without success. The parties to the transaction declined to discuss the terms of condition of the sale. According to the public records, there have been no other transfers of the subject property within the past 3 years. These types of comments are necessary so that intended users can properly understand the scope of work of the assignment. The Appraisal Foundation Uniform Standards of Professional Appraisal Practice, Washington, D.C. Appraisal Standards Board 2018 through 2019 edition. Advisory Opinion 1. 2. IBID. End of page. Jurisdictional exemption. The jurisdictional exemption rule, jur, states, if any applicable law or regulation precludes compliance with any part of USPAP, only that part of USPAP becomes void for that assignment. Comment. When a compliance with USPAP is required by federal law or regulation, no part of USPAP can be voided by a law or regulation of a state or local jurisdiction. The rule is intended as a saving clause, which preserves the balance of USPAP if compliance with a part of USPAP is precluded by law or regulation. In other words, if a law precludes you from complying with one part of USPAP, you cannot simply disregard the rest of USPAP. You would have to comply with the parts of USPAP that are still in effect. A jurisdictional exemption is only created if a specific law or regulation precludes compliance with a part or parts of USPAP. For example, a law that requires appraisers to retain their appraisal work files for 7 years would not be a jurisdictional exemption because nothing in the law would preclude an appraiser from complying with the USPAP minimum requirement of 5 years. An appraiser could comply with both the law and USPAP by retaining his or her work files for 7 years. Conversely, a law that required appraisers to dispose of their work files after 3 years would be considered a jurisdictional exemption because the law would preclude an appraiser from following USPAP and retaining his or her work file for 5 years. The appraiser would have to make a choice. Either follow the law or violate USPAP, or follow USPAP and violate the law. The jurisdictional exemption rule makes that an easy choice. The appraiser must follow the law and disregard the part of USPAP that has been voided. In real-life appraisal practice, there are very few jurisdictional exemptions. The Appraiser Foundation Uniform Standards of Professional Appraisal Practice, Washington, D.C. Appraisal Standards Board 2018 through 2019 edition. Jurisdictional exemption rule. End of page.